Good day, Sarah. How are you?
Fine, thank you.
I would like to talk today about litigation versus arbitration. Can you explain the main differences between litigation and arbitration?
Sure. First, I'd like to say that everything I'm about to say today deals with American law in American courts or American jurisdictions, either under the state system or under the federal system. In litigation, a litigated dispute is heard in state or federal court in the U.S. system, and those disputes are decided by a judge who is not selected by the parties. In arbitration, it's a dispute resolution process where the parties have to opt out in their contract or by a mutual decision, and the dispute is then heard in a private forum, which will be the dispute will be heard and decided by an arbitrator, a third party, who is selected by the parties themselves. Second, the 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 parties don't pay for the judge. The parties will pay a small filing fee, whether it's in state court or in federal court. With the arbitrators, the parties will split the fees of one arbitrator if they decide on one arbitrator, or they will split the fees of three arbitrators. And depending on the size of the dispute, the parties will decide to go with one arbitrator or with three arbitrators. Uh, One of the other main distinctions is that when you're in court, the judge may not have any experience at all in the subject matter of your dispute. In arbitration, when you select your arbitrators, both parties have a very, very strong interest in making sure that the arbitrators, whether it's one or three, as I said earlier, making sure that those arbitrators have quite a bit of experience in the subject matter of the dispute. Uh, Third, in court, the papers that you file with the court and the information in those papers is not confidential as a general matter. In arbitration, domestically, unless the parties opt out, all the information that you provide to the arbitrators is confidential.